Hi, and thank you for continuing this video with me through all its parts. So I initially said that I was going to be reading something from my book in the video. So I'm going to do that. And also, there were some other things I wanted to read that I'm not experienced enough to get the AI to sound how I want it to sound. And so I'm doing it like this portion like this for now. Um, so let's get started. The last quote that I read by Abraham Lincoln in this video actually is giving freedom to the slave. In giving freedom to the slave, we ensure freedom to the free. Now, there's a quote that Abraham Lincoln. So I bought these little books from the Barnes and Noble store. They were little one of them had the Constitution and all of the freedom papers in it, the Emancipation, the Bill of Rights, all of that was in there. And then the other one was famous quotes by Abraham Lincoln. And so um, I'm going to read one of them quotes, another quote by Abraham Lincoln that he where he mentions the Negroes and talks about the invention of the Negroes. Okay, so this is a quote from that book. The next quote is by Abraham Lincoln from lecture. This is page 62 of Amid the Twisted History. I got my fingers all in front. It's really blurry. Sorry. Okay, so page 62. Um, Abraham Lincoln from Lectures on Discoveries, Inventions, and Improvements. On February 11th, 1859, I have already imitated my opinion that in world history certain inventions and discoveries occurred of particular value on account of their great efficiency in facilitating all other inventions and discoveries. The discovery of America in 1492 and the first patent law in 1624. The two other especially important events, Mr. Lincoln states, are the Lutheran Reformation of 1517 and the creation of the Negroes in 1434. Now, so I wrote, so who had the patent on the Negro? This is very interesting and a very telling statement. Okay, so the other thing I wanted to read, so think about that, the creation of the Negro, or in the present way that we use them. Um, what was this? 1, 4. Um, oh, okay, sorry. This is page 90. But words on a papyrus cannot and will not change the hearts of men. Evil rests in the hearts of many Americans, and the hardened heart would only get harder. We see this as evident in the condition of our country today. Which one of us said, which one of you said, with a clean heart and a clear conscience, that America was ever great? What does it really mean? Is it in their greatness? Is it their greatness and ability? Is their greatness in the ability to create wealth, no matter the cost? Because it has never been morally correct. And it is even more crooked today than it's ever been before. Okay, so when I bought I purchased those books at the Barnes and Noble, the local Barnes and Noble store. I had, I don't know, it was a couple months later, I found an old copy. The copy was about 135 years old when I found it. It's about 142 years old now. But the books were being thrown away. And I just happened to see it and I was excited. I was like, oh, let me look in there and see if I see the Constitution. For some reason, I just had the feeling that something was wrong, that something had been changed. So I go and I compare the old 1883 version of the Constitution to the one that I had gotten from the Barnes and Noble store. And there was one word different. And so I am going to share that also with you. I'm not going to read it from my book. I'm going to read it from a copy that I made from the actual encyclopedia, which is about 6 foot long, but I'm only reading the 14th. I'm only reading the portion that's related to the 14th Amendment. All right. So it says in Article 1 of the Constitution, well, let's not read that part. Let's read, yeah, it's Article 1. No person shall be a representative who shall not have attained to the age of 25 years and been 7 years a citizen in the United States, and who shall not, when elected, be an inhabitant of that state in which he shall be chosen. Representatives and direct taxes, here it is. Representatives and direct taxes shall be apportioned among the several states, which may be included within the Union, according to their respective numbers, which shall be determined by adding the whole number of free persons, including those bound to service for a term of years, and excuse me, and including Indians not taxed 3/5 of all persons. Okay, so that's the way it read before the writing of the 13th, 14th, and 15th Amendment. Now, the word that is different is the word including, because no matter where you look today, online you can go to the Library of Congress, go to the actual 13th, the actual 14th Amendment, and read it's like the translated version. It's in printed version, but the actual Constitution was written in cursive. So if you can actually read that actual document, and you can see where the word used to be including, and somehow a little X was added to it. But I didn't know that until recently, until I was making the video, making gathering the information for this video. But I knew that it was different because of the old encyclopedia that I was able to get this copy out of. And so it said including the Indians, not exclude the Indians. So if they were to back then exclude the Indians, that are 3/5 of all other persons, then they wouldn't have been able to use them for their direct taxes. If they wouldn't have been able to use them to count to have the most numbers in Congress like the South did. And so at some point after 1879, this word including was extracted and excluding was replaced. And you can find that if you go to the Library of Congress, just type in the 14th Amendment. You want to put in everything that's related to the 14th Amendment. And then when you do that, you go to the, don't go to the transcript, go to the original pages, and then you will see up in the right hand corner, extracted text. And if you click that and go down, you will see where it says including Indians not layered. I don't know what all them other words are that's in there, but that word was taken out and excluding was put in. So someone was trying to, or it was an accident. I mean, I don't know, but nobody tried to fix it in 100 and almost 150 years. So let's see how birthright citizenship got added to immigration. I mean, I never really paid attention to it until now. There's calls to repeal the 14th Amendment again. That was a call back in 1870 or somewhere around in there. Yeah. So like soon as it was passed, you had representatives trying to get rid of it. That's what all of these black laws, all of these black codes and Jim Crow and discrimination and racism and all, it's been as if we were the problem. No, these people came to our land, enslaved our ancestors, and then said we were the problem. Okay. So we are the problem because we're in the way, right? They want us gone, take us to Africa. Then nobody's going to have any freedom. I don't believe that Americans understand what happened. Like once you deprived the Negro of his rights, you let go of your own. And this is what the founders was trying to say. They were trying to convey to the American people that their freedom was connected to the freedom of the Negroes. And because they were not allowed their freedom, somehow they were able to take the freedom away from everyone, right? So nobody really has true constitutionality because it wasn't given to the Negroes. And so I think I hope that I can show that with the rest of this video. Okay. So we just read um, that the Constitution, the 14th Amendment, has a typo, an error, whatever you want to call it. But it really throws off the understanding of the Constitution, because why would you exclude the people that we just fought over 200 years for? Why would we exclude them? That doesn't make any sense. However, so it says sometime between 1868 and 1879, the extraction was made to exclude the Indians. So now the original Constitution that we see anywhere online, it reads excluding Indians, 3/5 of all other persons. Now, if the direct taxes were being apportioned according to the number of people in your state, if you go back and change the word from including to excluding, then people cannot be counted as the 3/5 towards your numbers. The actual reading of this portion would not make any sense if this was the true way in which it was written in 1789. You can see this change on the Library of Congress website. Go to the 14th Amendment, like I said before, and look at the extracted text. Excuse me. First, it covers free persons and indentured persons, and lastly, it covers the slave population, including Indians, 3/5 of all other persons. Everyone else was counted as a whole person, except for the Indian/Negro that was in slavery, or the Indian that was in slavery being called a Negro. All right. So, um, this whole thing started with birthright slavery started with the Kim Wong Ark case. Kim Wong Ark was a Chinese immigrant, I guess. He could have been, I don't know. I'm not, the words say he was a Chinese immigrant. The court case says he was a Chinese immigrant. His parents were here as immigrant workers. They had him while they were here working. So they were here working, I guess, under the jurisdiction of the United States. So they weren't here like hiding. They were working on the railroad or whatever it was they were doing. And he went back to China with his parents. And when he came back to the United States, they wouldn't allow him to come into the country because they said that he wasn't a citizen. So the whole Supreme Court case um, came about, and he was fighting for his constitutional rights. Somehow they added that to the 14th Amendment when it shouldn't have been. However, he was protected under normal immigration. There's always been immigration policies here. Anybody from Europe can come freely, long as they're white. Okay, they come freely. Anybody from the Middle East, they can now come freely. But back then, it was just for European white people and Asian people. Okay, they were coming over here too as immigrant workers. And so the conclusion of that was, if we deny him rights as a citizen who was born in the United States, then we will have to deny Europeans who were not born in the United States. They just come over here and they get citizenship. So that's where birthright citizenship started, with the Kim Wong Ark case. And what year was that? This was, um, let's see, what year was it? I didn't even put that in here. Okay. It must have been, let me see. Let me check real quick. All right. So I've seen 1873. So it was 18, he was born in San Francisco in 1873 and had been denied reentry into the United States after a trip abroad under the Chinese Exclusion Act. Now, he wasn't denied it because of the Chinese Exclusion Act. That came afterwards. The Chinese Exclusion Act came after. It was 1898. 1898, and he was granted citizenship under the Citizenship Clause of the 14th Amendment. Now, he could have just been granted citizenship as an immigrant like everybody else. But I don't think that we understand that every time the Supreme Court tried a case, it was in an attempt to strip rights from citizens. Now, from American citizens, that would be the Negroes, because everybody else already had constitutionality. Okay, and then in the United States versus Rhodes, this was the Supreme Court again trying to take a case, and they were trying to explain the purpose for the 13th, 14th, and 15th. Well, the 13th of, actually, this was 1866. So this was just the 13th Amendment and the Civil Rights Act. Okay. So it says, the enemies of the Constitution saw many pearls of evil in the center, but none elsewhere. They feared tyranny in the head, not anarchy in the members, and they took their measures accordingly. The friends of the Constitution desired to obliviate all just grounds of apprehension and to give repose to the public mind. It was important to unite, as far as possible, the entire people in support of the new system which had been adopted. They felt the necessity of doing all in their power to remove every obstacle in the way of its success. The most momentous consequences of good or evil to the country were to follow the results of the experiment. Hence, the spirit of concession which animated the convention, and hence the adoption of these amendments after the work of the convention was done and had been approved by the people. The 12th Amendment grew out of the contest between Jefferson and Burr for presidency. The 13th Amendment is the last one made. It trenches directly upon the power of the states and of the people of the states. It is the first and only instance of a change in this character in the organic law. It is the first and only instance of a change of this character in the organic law. It destroyed the most important relation between capital and labor in all the states where slavery existed. It affected deeply the fortunes of a large portion of their people. It struck out the existence of millions of property. The measure was the consequence of a strife of opinion and a conflict of interests, real or imaginary. As old as the Constitution itself, these elements of discord grew in intensity. Their violence was increased by the throes and convulsions of a civil war. The impetuous vortex finally swallowed up the evil, and with it forever the power to restore it. Those who insisted upon the adoption of the amendment were animated by no spirit of vengeance. They sought security against the reoccurrence of sectional conflict. They felt that much was due to the African race for the part it had bore during the war. They were also impelled by a sense of right and a strong sense of justice to an unoffending and long-suffering people. These considerations must not be lost sight of when we come to examine the amendment in order to ascertain its proper construction. The first section enacts that all persons born in the United States and not subject to any foreign power, including Indians not taxed, are hereby declared. I put including back in there because it will still say including Indian not taxed, are hereby declared to be citizens of the United States, and such citizens of every race and color, without regard to any previous condition of slavery, shall have the same right in every state, in every territory in the United States. to make and enforce contracts, to sue, to be parties, be parties and give evidence, to inherit, purchase, sell, and convey real and personal property, and to full and equal benefits of all laws and proceedings for the security of persons and property as enjoyed by white citizens, and shall be subject to like punishment, pains, and penalties, and to none other any law, statute, ordinance, regulation, or custom to the contrary notwithstanding. So the Civil Rights Act, the 13th Amendment, was written to give freedom to the Negro Americans. Everybody else was already free. Everybody else. Even the new people that were coming to America from Europe automatically were citizens. So all of this was done to bring freedom to the Negro, but it also secured freedom for everyone. So if we didn't get it, nobody got it. That's the way I believe it. That's my humble opinion. Okay? The second section provides that any person who, under color of any law, statute, ordinance, regulation, or custom, shall subject or cause to be subjected any inhabitant of any state or territory to the deprivation of any right secured or protected by this act, or to different punishment, pains, or penalties on account of such person having at any time been held in the condition of slavery, or by reason of this, or by reason of his color or race, than is prescribed for the punishment of white persons, shall be deemed guilty of a misdemeanor. The third section declares that this District Court of the United States, within their respective districts, shall have exclusively of the courts of the several states cognizant of all crimes and offenses committed against the provision of this act, and also concurrently with the Circuit Court of the United States of all causes, civil and criminal, affecting persons who are denied or cannot enforce in the courts or judicial tribunals of the state where they may be. So basically saying if they can't get justice in the state where they may be, they can take it to a higher court. Um, First, by the first section of this act, and if any suit or prosecution, civil or criminal, shall be commenced in any state court against such persons for any cause whatsoever, such defendant shall have the right to remove such case for such cause for trial to the proper district or circuit court in the manner prescribed by the act relating to habeas corpus and regulating judicial proceedings in certain cases, approved March 3rd, 1863, and all acts amendatory thereof. It will be observed that jurisdiction is given to this court of all cases. This is the Supreme Court of all cases, civil and criminal, affecting persons who are denied or cannot enforce in the local state court any of the rights secured by the first section of this act. The denial of anyone is, excuse me, the denial of anyone is is as effectual as the denial of all other or of all. Okay? The denial of anyone is as effectual as the denial of any other or of all. So we're Americans were borderlining on, well, they borderlined on it, giving up everybody's rights. Because one thing that I learned also too when making this video was what it means to have the right of suffrage. The right of suffrage means to have a Republican form of government. So if once they gave the right to vote with the 15th Amendment, that brought about a Republican form of government. Before that, it was a majority rule. And we have been living under a majority rule for all this time. So we didn't get our constitutionality, neither did they, neither did anyone. Everyone should have been fighting for the constitutionality of the Negro Americans in order to secure freedom for everyone. Okay. When the act was passed, there was no state where ample division did not exist for the trial and punishment of persons of color of all offenses, and no locality where there was any difficulty in enforcing a law against them. There was no complaint upon the subject. The aid of Congress was not invoked in that direction. It is it is not denied that the first and second sections were designed solely for their benefit. The third section, given the jurisdiction to which this question relates, provides expressly that if sued or prosecuted in a state court under the circumstances mentioned, they may at once have the cause certified in a proper federal court. So this is saying that if they can't get justice in their state court, that they have a right to take it to a higher court. But none of those rights were given to them because we have not been living under this Constitution, the one that was written back then. I don't know. This is my humble opinion. So I don't know what's been going on, but according to the writers and according to the way things are written, we have a Republican form of government when we allow the right of suffrage, that is, allow the Negro vote. And since the Negro vote was denied them until almost 1970, what was going on for all those years? There was no Republican form of government happening if the Negro vote was denied. So this is not a Republican form. This was supposed to be a democratic republic in America with the Constitution. We haven't been living under a democratic republic. We've been living under a straight democracy where majority rules. Okay. And I believe, in my personal opinion, that that could be the reason for immigration, right? Because majority rule. You bring them in, you tell them what they need to do, who they need to vote for, and then, the agenda of the rich people continue. And that just adds to the more poor people in America. Okay, so let me see what else I wanted to read. Okay, so this United States versus Rhodes. Let me see what else I wanted. Okay, hold on. The difficulty was that that were what the difficulty was where a white man was sued by a colored man or was prosecuted for a crime against a colored man. Witnesses were excluded. Colored witnesses were excluded, so he couldn't bring witnesses. This in many cases involved a denial of justice. Crimes of the deepest dye were committed by white men with impunity. Courts and juries were frequently hostile to the colored man and administered justice, both civil and criminal, in a corresponding spirit. Congress met these evils by giving to the colored man everywhere the same right to testify as enjoyed by white citizens, abolishing the distinction between white and colored witnesses, and by giving to the courts of the United States jurisdiction of all causes, civil and criminal, which concerns him, wherever the right to testify as if he were white is denied to him or cannot be enforced in the local tribunals of the state, the context of rules of interpretation permit permit of no other construction. Such was clearly the intentions of Congress. Okay. It says there is no force in this argument. The statute